Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by a professor at Sheridan College. And thank you, first of all, Gargi, for joining us here today. And maybe you can start tell us a little bit about yourself, about what it's like teaching at Sheridan, and your long and distinguished career in criminal law, stops in Manitoba and in Ontario.
Okay, thank you very much, JP. First of all, congratulations on your 2-year anniversary for Justice in Pieces. I've noticed that you've had quite a few impressive guests over the last couple of years, and I'm just thankful that I'm not following someone like Jagmeet Singh, because I think he would be a very tough act to follow. So just in terms of my background, I articled for Manitoba Justice in the Crown Attorney's Office, and I stayed there for about 8 years afterwards. So I was a Crown Attorney, and I worked in many units. I specialized in youth matters and then the family violence unit for a few years. And towards the end of my career in Manitoba, I finished in the major trial unit, which dealt with various indictable offenses and trials. So since that time, I moved to Windsor, Ontario, and I was a Crown Attorney in Windsor for a few years, couple of years. And I changed positions to join the Windsor Essex Children's Aid Society as in-house counsel. So my background is definitely within criminal law and child protection law. Within a short time from then, I had twin boys. And so I decided to go back to school, and I completed a Master's of Education in Education Law and Policy. At the same time, I started teaching at University of Windsor Law School as a sessional instructor. And at the same time, I was also commuting to this area, to Sheridan College, as a part-time instructor. So I was kind of working in between Windsor and Brampton for some time. I've been at Sheridan College now for almost 10 years as a full-time professor. I teach mainly in the paralegal program, but also in the police foundations and honors Bachelor of Community Safety degree. So a lot of the criminal law types of courses, evidence, provincial offenses, and advocacy, those are my favorites. I love to coach mock trials, and I know that JP, you and I were recently part of the Dominion mock trial, so that was very exciting. So that's really essentially a little bio about me.
Perfect. So thanks for sharing all that. And certainly, maybe I guess a follow up, because we're going to talk about one of the books there in particular, because I think, at all the different paralegal colleges I've taught at, that they all use the first edition. I know the second edition just came out in January. So how did that come about in terms of, and I know you have another textbook as well that's not for the paralegals per se, but also related to legal textbooks for I think more for police foundation students, I guess. So how did that kind of come around? I know you've been a professor for 10 years there at Sheridan. Where did the idea of doing, I think the book was 2014, so it's almost 8 years now.
Yeah, it was late 2014, early 2015. And the idea actually came about as a result of my students. So while I was teaching in summary conviction for paralegals, there was no textbook. So there was really the criminal code, and in addition to whatever materials we used in class. So over time, quite a few students suggested that I should think about writing a textbook and put in some of my cases and annotations in there just to make it more of a resource. And so, around that time, I thought, well, maybe I'll give it a shot. So I proposed the idea to Iman Montgomery, and they were very much on board with it. And that was the whole reason why the first textbook came out. So that was, late 2014, early 2015. But, the second edition just coming out in January, it was long overdue for an update, especially with the passing of Bill C-75 in 2019. So it was about time that, I revised this and came out with a more current edition. So, and I'm very happy that it's been out now for a couple of months. So in terms of my other textbook, there is the second textbook that I wrote was the Foundations of Criminal and Civil Law in Canada. So that is the 5th edition that came out last January, so January of 2021. And that book was co-authored with Alison Kosowski from Georgian College. So the two of us decided to come up with the 5th edition, the revision for it. And as you mentioned, that textbook is more for law enforcement or police foundation students. So the focus more is on police powers and whatnot. So those are the two texts that I have out right now.
Perfect. And certainly maybe you can tell us some of, there's been exhaustive updates in particular, obviously the scope there, but I know as it starts to filter over, I mean, obviously with the changes in the law, I mean, maybe you can give us some highlights there. What's in the 2022 edition versus the previous one from the end of 2014?
Sure. So I have made quite a few changes in the new edition, the second edition. So first of all, because of Bill C-75, of course, with the change of the paralegal scope, there's a bit of a history and an update with respect to the differences in the criminal code. Certainly the changes to the general penalty section. Of course, we know with the period of incarceration now being changed from maximum of 6 months to a maximum of 2 years less 1 day jail. So that was one of the big areas. In addition to that, there's been additional changes with respect to bail, adding more cases with respect to bail provisions. So certainly in Ontario, there has been more of a move towards making sure that conditions as part of release on bail are conditions that can be met by the accused. So certainly there's been a line of cases that have been included with respect to that chapter. There is another additional chapter that I've added in the second edition, chapter 10, which talks about other types of courts. So first of all, the Gladue courts and how they operate. Also drug treatment court. So whenever there's a substance abuse issue that's involved, the defendant has an opportunity to be transferred to drug treatment court. And the third area that's mentioned under chapter 10 is the mental health court system. So that is another specialized court. Also, chapter 10 has a number of common offenses that paralegals may be dealing with in their practice. So I've taken about 10 common offenses and I've provided a brief write-up of each of those offenses. So everything from the elements of the offense, the mental intention that's required, plus various examples of those offenses. In addition to that, throughout the book, there have been updated cases. So again, more cases that are recent, in line with the legal principles that are included in the textbook. There are various worksheets that we can take a look at, as well as, other features. There's the rules, the criminal rules of the criminal rules of the Ontario Court of Justice. Those are reproduced, as well as all the different forms under the criminal code, right? Any of the orders that may be made by the court. So it's fairly comprehensive, probably 1.5 times thicker than the previous text, right? So it's more comprehensive, it's more modernized. There's a lot of information about the effects of COVID throughout. So, we talk about the Jordan case in terms of a delay application. We talk about diversion programs. So just a lot more to it than the previous edition.
Yeah, that's great. I mean, I'm looking forward as we kind of roll over in all the places I'm teaching at to kind of have, rather than say, okay, by the way, here's where the laws are and the new case law. So it's nice to have something that's updated, being around now because of all of the changes over the last 8 years. And I think, I really like as well about the layout of the book. It kind of goes from the beginning right through till sentencing and touches again as well on the potential for any appeals there. But again, it kind of goes chronologically. So it's really great to teach because you're following kind of, a matter from beginning to end. And I thought maybe this is something great because the last week I was talking with Jonathan Rosenthal, so from the criminal defense side of beginning to end. And now you can kind of give us the perspective from the Crown side of when something comes your way till trial and beyond. So maybe we can start with when it first arrives, right, is that there is the information and what happens next from the Crown side when we're getting ready for the first appearance of the accused.
Okay, so JP, I'm going to assume that your students have already discussed bail, court, and applying for bail, if that's one of the considerations.
Yeah, or maybe actually let's start with bail then, right? I mean, because obviously there's the other side there to it. If someone is being detained, right, that the police are not
Yes.
releasing them, well, let's now look at it. What are the things that a crown attorney is looking at in terms of detaining someone, and what are the grounds, and how that process works from that side?
Certainly. So when a defendant appears in bail court, one of the first things that the Crown does is to check to see if there are any pending charges. So they're looking for any charges for which the defendant was already released when they are alleged to have committed what they're facing now. So if they were already on a release order, then we refer to that situation as a reverse onus. So a reverse onus means that the onus is on the accused to show that they're a candidate to be released on bail. On the other hand, if they're not pending on any charges, they haven't been alleged to have committed any offenses when they got involved in the offense before the court, then it's a Crown onus bail. So that means the Crown has to show cause to the court why the accused person should be released on strict conditions or not released at all. So that's one of the first things that the Crown looks for. If the accused is pending on charges, then the Crown can ask for a short adjournment to bring all of those pending charges together and ask for the accused person's release to be canceled on those previous charges. So then the Crown, in effect, is asking that the accused be kept in custody, not only for the charge that they're facing now, but for previous charges on which they were already released. So once the Crown reviews the file to determine whether it's a reverse onus or not, they then have to consider on which ground or grounds they are opposed to the person's release. So there are 3 grounds that the Crown takes into account, and they're referred to as the primary, the secondary, and the tertiary ground. So on the primary ground, the Crown is considering whether the person will show up in court if they are released on bail. So the only concern is whether or not they will show up in court. I might want to ask your students, what do you think are some of the reasons why the Crown might be opposed to someone's release on the primary ground? What might they point to as evidence that if the accused is released, they're not going to show up in court? I don't know if anyone has any ideas.
You can always post it here in the chat there as well.
Oh, okay. That's a good idea. I'll do that as we talk about this. So what do you think are some reasons why the Crown would believe that someone will not show up in court if they are released on bail?
And for the students, again, you can type your response there as well while we're still chatting here. So, so while that comes in, what sort of what's the procedure there in terms of things that are happening afterwards, and does it necessarily mean that? What are you looking at when you're screening? Kind of, is there a possibility that hopefully these answers that are going to come from the students there can be addressed by counsel for the defense, and is the Crown satisfied then as a result?
Right. So some of those things that the Crown's looking for. So if the person has a previous record, right? So, oh, okay. So there's an answer that someone's posted. Thank you, Julia. Any kind of indication that the accused might leave the country, right? So if they have ties to another country, let's say that they were formerly a resident in the US, or they've made comments that as soon as they're released, they're going to leave the jurisdiction. Those are obviously reasons why the Crown may have concerns on the primary ground, right? The Crown also has access to the accused's record, right? So, okay, so thank you, Asaf. You said there's a possibility of absconding. So meaning if they're released, there's a possibility that they will run. Maybe they've made comments to the police to that effect, right? Maybe they've made comments about, trying to leave the province, right? So those things could be indicators of primary ground concerns. Another thing that the Crown may look at is the person's criminal record, right? So do they have a history of not showing up in court? Do they have a history of not following court orders? So that is also a primary ground concern, right? And yes, Natalie, they could have expressly said that they're not going to show up if they're released, right? Something like, as soon as I get out of here, that's it, I'm leaving for Florida, right? So those are obvious indicators of primary ground concerns. In terms of making sure that that concern is addressed, can you think of anything that defense counsel might propose as a bail plan? So let me just post that here. Bail plan for an accused person where the Crown has primary ground concerns. What might the defense counsel propose to ensure that the Crown does not have to worry about whether the person will show up in court? One of the more easy conditions is to surrender passport, right? So they would ask the defendant to surrender their passport, and they would not receive it back until they have dealt with their criminal charges, right? So handing over one's passport, having a surety is another great answer, right? So a surety, does anyone know who or what a surety is? I don't know if you've talked about this yet in your course.
Yep, we have, so they should know. So I guess
Okay.
Relative here. And
yep, so it could be a family member who comes forward as a surety. It could be someone who is a friend of the accused, right? So friend or relative. Usually that person has to have some kind of control over the defendant, right? Is able to supervise them, right? So someone who has some degree of supervisory power, they can ensure that the person follows their conditions. Yeah, someone who agrees to take responsibility for the accused. Exactly. There's been a line of cases, though, in Ontario that say that sureties should only be imposed as a last resort. So what they say is that where the Crown and defense can ensure that the accused will follow conditions, they should only rely on a surety if there's nothing else which is reasonable, right? Nothing else would address the concerns. So the judges and the courts don't want us to automatically ask for a surety. And the reason for that is that a lot of accused persons are not able to meet the conditions for a surety. A surety has to, what does a surety have to do in order to be accepted as a surety? Okay, so a surety has to have no criminal record, that's right. But in terms of the financial part of it, what does a surety have to show? A surety has to be okay. So not only a promise to pay, but they have to show that they have some kind of financial guarantee, right? So that could be to show that they're a homeowner, right? So they own a house, or they have some kind of cash deposit to prove to the court that they're good for the money. So a surety is always in a financial amount, like a surety of $1,000 or a surety of $5,000. So before a person can be a surety, they have to show the court that they actually can act upon that promise. And if the accused person breaches a bail condition, the surety is on the line for that amount of money. So a surety could potentially lose their home or lose their assets if the person defaults on the bail conditions. So because of that, the courts don't want a surety imposed for every accused person who comes before the court. So, and that is something that can guarantee a primary ground concern. Another ground that the Crown may oppose someone's bail on is the secondary ground. Any thoughts on what the secondary ground includes? So what type of concern is a secondary ground concern? Exactly. So Natalie is correct. A secondary ground concern means that the accused is a danger to the public. And the Crown is fearful that if the accused is released from jail, from custody, that they will reoffend against either a victim that they've been involved with, or they will commit other offenses once they're released. So secondary ground is always concerned for the safety of the public, right? And just like the primary ground, the defense can suggest conditions which may help the Crown's concern on the secondary ground. What conditions do you think the defense could suggest to address the secondary ground concerns? If someone is a danger to the public, we might put conditions on them that they have no contact or communication, either directly or indirectly, with any victim or witness in the case, right? So that's one condition. There may be another condition that they not attend to any place where the victim or witness either lives or is employed or attends. So if the witness attends a college, the condition might be that the defendant not attend to that college, right? So a non-attendance condition. They can't go any place where the victim or witness may be. In addition to that, there may be a condition that the person, the defendant, has to report to the police, right? Local police station. It could be once every 2 weeks or once a month, okay? Just to show that they've been staying out of trouble, right? There might be a reporting condition. If we think about it, there may be several other conditions, right? So in addition to no contact, non-attendance, reporting to the police, they may have to appear in court on all the court dates, right? To make sure the court knows where they are, or other conditions that are similar to that, right? So those may address the secondary ground. The last ground that the Crown could use to oppose someone's release is a ground called a tertiary ground. And this one is the most controversial, right? The tertiary ground means there's no concern that they won't show up in court if they're released. There's not necessarily a concern that they will be a danger to certain person or persons if they're released. But the tertiary ground says that based on the seriousness of the case, right? So serious allegations, and the Crown's case being very strong, and the potential for the accused to go to jail if they are convicted. So if they are convicted, it is very likely that they're going to go to jail. And the Crown's case is very strong. And there's also a component of if the person is released on this charge, the public may be very, not outraged, but the public may look down upon the judicial system, right? So that is sort of what the tertiary ground tells us. It's not used all the time, but it can be used in combination with a primary or secondary ground. And again, it's used for those cases where maybe the person doesn't have any previous record, but what they're charged with now is so controversial or is so serious that they should not be released. Let me talk about an example of this. Do you all remember the case of Chair Girl, right? Chair Girl, who was charged with throwing a chair off of Airbnb rental in Toronto, right? And that was very serious because it landed on the highway and there was a potential for someone to be very seriously injured, right? She didn't have, yeah, she threw it on the highway, right? She didn't have a record, so we can't say that there's a concern that she'll breach court orders if she's released. There's no primary ground concern. And, you know, if we put strict conditions on her, we can probably say that there are no secondary ground concerns because she's unlikely to go to another place and throw a chair off of a high balcony, right? That's not likely. But when we consider the tertiary ground, we might think, you know what, these are really serious allegations. Someone could have been seriously injured or killed. And, you know, we have this recorded. So there's a lot of evidence against this person. And you know what, if she's convicted, she's maybe looking at jail. I'm not saying that's true, but I'm saying had that been the case, then that might have been a situation where the Crown might be opposed to that person's release on the tertiary ground. Okay, so there's an example of the tertiary ground. So the primary, secondary, and tertiary grounds are the grounds upon which the Crown may be opposed to somebody's release. If it is a Crown onus situation, then the Crown has to convince the court that if the person is released, they're going to breach bail conditions, that they're not a candidate to be released. If it is a reverse onus, the onus changes from the Crown to the accused. And the accused has to show that if they are a good candidate for release, that they'll follow any conditions that they're placed on and that they won't breach their bail. So that is sort of leading up to the actual bail application. All right. So I don't know, JP, if you have any questions for me at this point.
Yeah. So, I mean, I guess now we look at, you know, where we were kind of before this. Right now, they've got through either they're in custody still or they've been released on, you know, whatever, if there's conditions, if there's sureties, etc. What then happens next, you know, with the file on the Crown's desk with the next step in the process?
Okay. So assuming that the person has been released from custody, once they're released, they have a court appearance in which they have to attend court. And, you know, potentially they've already gone to a paralegal if it's a summary conviction matter, and they've hired a paralegal to represent them in court, or maybe they haven't, right? Maybe they go to the first appearance on their own. So once they appear in court, usually on the first appearance, the Crown may have a disclosure package available. And that disclosure package may not be everything in the Crown's file, but it's a copy of some of the key items of evidence against the accused, right? So key items of evidence, I don't know if you guys are familiar with the Crown's file or the type of evidence that may be gathered in a summary conviction case, but can you think of some of the key pieces of information that might be available at this stage to give to the accused? So what may be a part of disclosure at this first appearance? What about the charging document? What is that called? The document with the charges on it. So we refer to that as the information, right? So the information is part of the initial disclosure, the charges. There may be a release order from bail court, right? Which has all of the conditions that the accused has to abide by. So that release order would be part of disclosure. There may be a statement or statements from the complainant, the person who has made a complaint to the police, and or from witnesses. Okay, there may be a police report that's available at this stage. There may be some police notes. There may be a statement from the accused, if the accused gave a statement, right? So these are sort of the initial items of disclosure, the things that come in first to the Crown. Not everything that's there on the first court appearance is part of full disclosure. So there may be additional things that the defense decides to ask for once they review that initial disclosure. But pretty much these items that I've listed here are part of that initial disclosure package. Okay. In addition to that, there's also another document that the Crown provides to the accused, which is called a charge screening form. And a charge screening form has some initial information such as what is the Crown asking for on an early guilty plea. So an example of this would be if the defendant pleads guilty in the first 3 months of being charged, the Crown is offering probation on a guilty plea, right? No fine, no jail. So that might be an early offer on a guilty plea. As other information on the charge screening form might be whether the matter is suitable for diversion. Okay, so that's another thing that the Crown would indicate. The Crown may indicate how the Crown is proceeding. This is something that's important to paralegals, right? Are they proceeding by way of summary conviction, or are they proceeding by way of indictment? Okay, so that's another consideration. Other information, so what is the Crown's position if the matter goes to trial? So if the case does not proceed by way of a guilty plea, if there's going to be a trial, what will the Crown ask for? So sometimes the Crown offers a better position on a guilty plea than they would if the matter goes to trial. So the Crown might say, if your client pleads guilty, we'll ask for no jail, we'll ask for a fine only. But if the matter goes to trial, we may ask for 30 days jail, right? So that can be something that's indicated on the charge screening form. What other information? So other information may be some instructions on how to apply for legal aid. Okay, there may be conditions that are attached to the disclosure, right? So typical conditions may include, you can't post or copy or, provide copies to anybody else other than your paralegal or your legal representative, right? Or if you're reviewing disclosure, it has to be with your representative in their office, right? Or if you lose the disclosure, you may have to pay for the cost of copying it if we have to give it to you a second time, right? So there may be various conditions that are attached to the disclosure. So that would also be set out in the charge screening form. Okay, so any questions about the initial disclosure? So as I said, you're not given everything as part of the initial disclosure. So once you review the disclosure, let's say that the person goes to a legal representative and retains them, and they review that initial disclosure with their paralegal. Once they review the disclosure, they might notice that there's some additional things that are missing and they need to request it, right? So any special items that are not automatically given, those might have to be requested, right? So things that have to be specially requested might be a report from an expert, right? So if there's an expert involved in analyzing any kind of DNA or, testing some kind of sample, then there might be an expert witness report that they have to ask for. There might be a use of force report. So if the police had to use any kind of force or, pepper spray or anything like that, they would have to fill out a special use of force report. So if the paralegal and the client go through the police notes and they see reference to any force that was used, chances are that there's a use of force report out there. Another thing might be any copies of search warrants, right? Or information to obtain, which the police would fill out if they conducted a search. So this might have to be requested if there's evidence that a search was carried out. Any identification evidence. So in Canada, we have the photo gallery packs where the police show a number of images to witnesses and they're asked if they recognize anyone in those photographs, and the witness has the chance to say whether or not they recognize someone. So that is referred to as a photo gallery pack. So copies of that may have to be requested for disclosure. Another thing is a 911 transcript, right? So sometimes the defense may not be aware of that until they start reading through witness statements. So if they believe that there's a 911 transcript involved, they have to ask for it. And that 911 call has to be transcribed. So a copy of that may have to be requested. If there were other people who were involved, so other professionals who were involved in the investigation, such as doctors, paramedics, right? Think of an assault where someone calls for help. The paramedics arrive. The paramedics have those pictures or images where they indicate where the person was injured, maybe where the victim was injured. So if you're wanting a copy of that report, you might have to specially request it, right? So any reports of doctors, paramedics, firefighters, that would have to be requested. Whenever the defense is asking for the criminal record of a witness, that's not automatically provided by the Crown. So that would have to be specially requested. And the last area that's mentioned in the textbook is police disciplinary records. So if the investigating officers are involved in any criminal offense or any offense for which they have been disciplined, then that is something that they have to now provide to the Crown if it's relevant, and based on a case called McNeil, right? So police disciplinary records also have to be specially requested. So these are not things that you might automatically get if you're the representative. You might have to send an additional request. So once you do, then the Crown has to adjourn the case to a different day, a different court date, and they have to wait for those items to come in. So once they come in, they would provide you copies of that disclosure, right? And then the matter would then proceed to being ready to set for a trial if it's going to trial. Okay, so that's just the disclosure stage. In addition to that, there are also pre-trial conferences. There is a Crown pre-trial conference and a judicial pre-trial conference. Okay. So a Crown pretrial conference is an informal meeting between the Crown and the defense paralegal. The client or the accused is not present. And it's the chance for the Crown to discuss the case with the defense. So everything from, is there going to be some kind of a charter issue? Is there going to be an application to exclude evidence? How many witnesses the Crown might be calling, right? How long they expect the trial will take from each party's perspective. So a lot of those issues are discussed informally at a Crown pretrial conference. It's also an opportunity for the Crown and defense to talk about any strengths and weaknesses of the Crown's case, what the legal issues are, if there are any defenses that the defense thinks are very strong that they may rely on, right? If any of the witnesses or parties require an interpreter. So a lot of those administrative matters which are involved in the trial. At the pretrial conference, the parties may also discuss any kind of plea bargaining that may take place if there's an opportunity to resolve the matter without going to trial. So any of those resolution types of discussions would also take place. Okay, so the paralegal should prepare for the Crown pretrial by creating a checklist and, putting down all the matters that need to be discussed. After the Crown pretrial conference, the defense should meet with their client and discuss what was discussed at the Crown pretrial, right? If the Crown provided any kind of offer in terms of working out the matter with a plea bargain, then that is something that has to be put to the client. Even if the paralegal doesn't agree with the offer, they still have an ethical obligation to put that offer before the client. Any kind of agreements that were made between the Crown and the defense, that should be followed up with a letter to the Crown. So again, just to clarify, this was what was discussed at the meeting. This is what was agreed to, right? Remember that whoever is the Crown showing up at the pretrial conference or any of the earlier court dates may not be the ultimate Crown who's dealing with the trial, may not be the trial Crown, right? Trial Crowns are usually assigned closer to the trial date. So that's the Crown pretrial conference. There's also a judicial pretrial conference. So a judicial pretrial conference takes place whenever a trial is expected to last for 2 or more days. So anytime a trial is over 2 days or 2 or more days, they have to have a judicial pretrial conference. And that is before a judge who will not be the trial judge. And the purpose of that is to ensure that whoever is the judge has a frank conversation with both the Crown and defense and is not biased by anything that's discussed, right? It's not the trial judge. So that can take place by way of phone or Zoom or whatnot. It doesn't have to be face-to-face. But, at the pretrial conference, both the Crown and defense have to be fully prepared. So again, they should be prepared to talk about a plea, whether the matter can be resolved without a trial. If the defense feels that they have a very strong case, then they should be prepared to talk freely about the evidence, right? What else? So, there may be some pressure placed on the Crown to work out an offer or perhaps not to even proceed with the case, depending on how strong or how weak the case is. Any kind of agreements as to trial. So if there are issues that can be by agreement where you don't need additional witnesses to prove those things, that is discussed as well. So the judge can put some pressure on the Crown and the defense to work out some agreements, even if there is a trial. If there are any pretrial applications that are going to be brought by the defense, so let's say the defense anticipates that they're going to bring a delay argument. That is something that they would need to notify the pretrial judge about. At the end of the pretrial conference, the judge sends out a memo to both the Crown and the defense, confirming everything that was discussed and confirming, the Crown's position and the defense's position. And once again, if there's any kind of resolution or offer made by the Crown, that has to be discussed with the client in order to comply with the ethical obligations of the paralegal. Right, so that, in a nutshell, covers the Crown pretrial conference and the judicial pretrial conference.
Okay, so then afterwards, I know you touched on some of those applications there. I know there's the whole chapter there, but anything maybe from, and I know we're almost out of time there, but let's say like the trial and the sentencing, which are units and units on their own, but anything you can share, what maybe you share with your own students there about preparing for trial and sentencing there, that, if they go on and practice, what are some considerations? Again, what is the Crown looking at in particular in those areas. I mean, I know it's probably hard to kind of come up with, a quick few minutes there in trial preparation and in sentencing, but looking back in your career, what were some of the things that, when it was on the eve of trial, or even if there was a resolution and it was sentencing, what you would be looking at?
Okay, so I think one of the main ways to prepare, regardless of whether you're Crown or defense, in terms of preparing for trial, is to create a checklist of all the elements of the offense. So even when I was articling and starting off as a Crown, I would go into whatever offense or whatever case I was prosecuting, and I would make a note of all the mens rea, right? All the mens rea elements, the mental intention of the accused, and all the actus reus components, right? So all the parts of the physical act that the Crown has to prove, as well as proof of identification, and any other elements that have to be proven, right? And as the Crown, you need to know this because you know that you have to meet a prima facie case by the end of the Crown's case. You have to have some evidence of every element that's involved. So having a good idea of what those elements are is crucial in terms of being able to prove your case. As the defense, the elements of the offense are also important because as you're listening to the Crown present their case, you're hopefully making a note of which elements are weaker, which element is missing evidence, or which element will it be easy for you to cross-examine and show a doubt. So both the Crown and the defense should have some clear idea as to what those essential elements are. So that would be something that I would do if I'm starting to put in trials. After a certain period of time, when you have, put in the same type of trial, whether it's provincial offenses or whether it's, a criminal matter, you start knowing those elements. So you get more used to knowing what you have to prove, right? So making one of those charts or checklists, and then, making note of who's going to prove that element. So as the Crown, you want to know which witness am I going to call that will help me prove the identification of the accused? And then what questions will I ask them to prove that element? So it's almost like working it out as a chart. So I hope that answers your question, JP. I know everybody prepares differently, but that's sort of what I would start with.
No, that's great. And I think then maybe the last piece there, just to kind of put a nice bow tie on everything, is in the sentencing stage. And we were talking about Chair Girl earlier, but maybe you can use that as an example of, what are the considerations the Crown would have in sentencing someone. I mean, in the various options that they may be asking for.
Okay, so some of the things that the Crown would be looking for is to see if there are any aggravating factors in sentencing, right? So aggravating factors are things that would make the sentence more, or would make the sentence harsher, right? It would make the sentence more strict. So aggravating factors can be anything from an offense which is hate motivated, right? Or is, committed out of bias, right? Any of those grounds, hate motivated grounds. So that would be an aggravating factor. As of Bill C-75 being passed, there's a new aggravating factor, which is intimate partner violence. So if someone has been convicted of an offense involving their intimate partner, and the definition of intimate partner has been broadened to include not just someone's spouse, but also their if it's a common law partner or even a dating partner. So there's nothing saying that a relationship has to be long-term in order for the partner to be considered an intimate partner. So if someone has a conviction involving an intimate partner and they are re-involved in another offense involving the same or a different intimate partner, that is an aggravating factor. Other aggravating factors, if the offense has had a really severe impact based on the victim's age, physical health, or financial situation, right? So basically an offense against a victim who may be of elderly age, who has a more severe impact because of their age, right? Or who was selected based on their medical condition, right? So all of those things are aggravating factors. Previous record is another one, right? If the person has a related record and a long record, then that is also something that's aggravating. So all of these aggravating factors are set out in the criminal code. So those are some of the things that the Crown would be looking at. And if they're present, then the Crown's position on sentence may be more harsh than otherwise it would be.
Perfect. So I think that's a great overview there. We've covered kind of from the bail stage right through until sentencing. And one of the things, I mean, certainly you've had so many years of teaching paralegal students in particular. I mean, I know I've talked with people from the law society, and that doesn't tend to be an area where there's a lot of paralegals practicing. So what maybe you share with your own students that you can share with my students about kind of getting into criminal law, and if that's something that you may be interested in, and what are the different opportunities that could arise for you, and hopefully we see more paralegals practicing in that area.
Certainly. So, I mean, some of the tips that I give my students is, so first of all, criminal law involves advocacy, right? So going before the court, whether you're the Crown or whether you're the defense. So I'm a firm believer that students should try to get involved in as many advocacy opportunities as possible. So that means signing up for mock trials, which allows you to network with people who are in the criminal field, right? Especially if it's a criminal mock trial. So, other paralegals, other lawyers, other students. It's just a great way to not only network, but also brush up on your advocacy skills and also gain some confidence, right? So that's probably my number one tip. Number two, something that I used to do as a law student, is watch as many trials as possible. So go into court. Right now, there's a lot of proceedings on Zoom, so you can watch trials on Zoom. But also when things go back to normal, certainly go in when you have some time and watch trials. There's nothing like watching someone skillfully perform a cross-examination of a witness. You just pick up so much from watching that. So certainly I would encourage people to go and watch cases. And another tip would be, whenever possible, and I know it's not always possible, especially after COVID, but, looking into any opportunity to put in some volunteer hours, whether it's at a legal aid clinic or a law office, even if it's just a few hours per week. So this really allows you to add this to your resume. So, once you write your licensing exam, people are always looking for licensed paralegals with experience. And the questions we always get is that, how do I gain experience if I'm just starting out? And so, volunteer work is something that you can definitely add to your application. And once again, it allows you to meet other people in the same field. You can find out about events which are hosted by the Law Society or by the Ontario Paralegal Association. So, just a great opportunity for you to get your name out there, right? So I would suggest all three of those things, actually.
Great. And so thank you. I mean, it's just at 6 o'clock here. So thank you so much for taking the time here, joining us, sharing all of that, kind of going through from beginning to end there. And certainly, obviously, it's great to have, the author to kind of put a voice there to, what we've been reading, or what I've been at least reading for like the last 7-8 years of teaching criminal law at the various schools I've been at. So, I mean, I know you just gave a lot of really great advice there, but any final words of wisdom for paralegal students studying criminal law, or anyone listening about getting into the profession? And once again, thanks so much for taking the time and joining us.
Thank you. Thanks for the opportunity to come and speak to your students here today. I would just say that, if you're passionate about criminal law as much as I am, and as much as some of my students are, then, don't worry about the fact that there's not a lot of paralegals necessarily in that area of practice. It's a developing area, and the Law Society has made clear that paralegals do have a recognized scope. So, if it's something you're really passionate about, then certainly find ways to, get involved in that particular community, and seize any opportunity that comes your way. So my advice would be, go for it.
Perfect. Great. So thanks again. And thanks everyone for tuning in, and take care, everyone.
Thank you.